Not only does my firm do the workers' comp contested hearings before the Industrial Commission, um, but I personally have been Spooner's labor and employment lawyer for 35 years. About 35 years ago, I met Tom Spooner, the founder of Spooner Inc., um, at um, uh, at a arbitration where I was representing a mutual client and Tom was a witness. He thought I was a good lawyer and I thought he was a good witness. And so I started representing the company. But even before that, I was referring clients to Spooner because I knew from the experience of, again, mutual clients, as well as the experience of clients who were using a TPA other than Spooner, that Spooner did a much better job than other TPAs in managing workers' comp claims and flagging for their employers the bad claims and figuring out how a bad claim could possibly affect your experience and your premiums, and um, uh, sending you to a lawyer in time to be able to do something about it. So as I said, I think you are already one step ahead of many employers in Ohio because you picked Spooner to be your representative. The three people who are talking today, me, Morris, and Barry, are all labor and employment lawyers with Roetzel and Andress, and all three of us have experience in all aspects of labor and employment law, including workers' compensation. All three of us also have experience in traditional labor work, which, dealing with the union. So if you have a union, we can give you advice on how that might affect dealing with an employee who's got a disability or who has a workers' comp claim or both. When we, in today's briefing, we're going to cover a couple things. One is we're going to talk about the new recreational marijuana law and how it affects employers' rights in the workplace. And again, I know from the questions that we got at the beginning, when people signed up, that this is an issue that's on the top of people's minds. And so we're going to address that in today. In addition, we're going to address how three laws, the ADA, the FMLA, and the workers' compensation statute interact with each other. One of the things that we have learned when a client asks us about what can I do with this injured employee is sometimes people are not aware of how the ADA and the FMLA or Ohio discrimination laws work together. And then finally, we're going to cover how the new temporary total disability law can affect an employer who fires an employee with a workers' compensation injury. I mentioned that Morris, Barry, and I all do labor and employment law as well as workers' compensation. I will say a couple things about Barry and Morris. Besides the fact that they haven't been practicing quite as long as I have been. But Barry, in addition to being admitted to the practice of law in Ohio, apparently either likes taking tests or he's a glutton for punishment because he's a certified labor and employment specialist in Ohio. He is also licensed to practice in Illinois, Michigan, and West Virginia. So a lot of our clients seem to have facilities in neighboring states, and Barry can help you with those issues. Morris has been working with me longer than Barry has, and has been doing work for Spooner clients for at least 20 years, I would say. Morris, in addition to doing traditional labor and employment work and workers' comp, also does employee benefits. And you can ask me as much as you want about employee benefits, and I will always say I need Morris to answer that question. Before we get started, this is why I asked you to keep your cell phones out. In order to participate in the polls that are coming up, you need to text the phrase Roetzel and Andress 322 to the phone number 22333 to participate in the upcoming questions. And our litigation support person put up nice pictures of how that should look if you do the texting. And I'll give everybody a couple minutes to join the poll, but that third slide is what your phone should look like if you've successfully texted the phrase to the correct number. Okay. And now we're going to do our first poll. It'll give me a chance to, well, give us a chance to get to know you and some background on the participants in today's panel, and also we can test the polling software. For the first poll, text to the number your answer to the following questions of how many private sector employees do you have? Text A if it's 50 or more, B if it's fewer than 50, but you've had 50 in the past. C if your company employs fewer than 50. D, none if you work for a public employer, or E, none because you work for a school board or school board employer. And I can see I don't know if everybody can see this, but I can see if how many people have answered. So I'll wait until I think our answers are being entered before I go to the next page. Okay. I have 16 answers and I don't know. Oh, never mind. It's moving again. Okay, I have 21 answers, and so I'm going to close the poll now. And those of you who haven't gotten to join yet, oh, never mind, I'm not closing. Every time we have a poll, it'll remind you of, if you haven't already joined the group, what number to text to. So we have 23 answers. I will go to the next thing. Okay, 65% of you have 50 or more employees, so you're covered by the FMLA. Those of you who have fewer than 50, but have had 50 or more in the past, you might be covered by the FMLA because there's a look back to see how many people. Only 9% of you have fewer than 50 employees and aren't covered by the FMLA. So as you can see, the purpose of this was just to determine how many of you are covered by the FMLA. Those of you who work for a public employer, whether it's federal, state, or local government employers, you're covered by the FMLA regardless of the number of employees you have. You could have one employee and you're covered. The same is true for local educational agencies concerning public school boards, public elementary and secondary schools. You are going to be covered by the FMLA regardless of how many employees you have. Those of you who picked B, that you don't currently have 50 employees, but you have in the past, whenever you have an employee go off, take off work for a reason that could be an FMLA type reason because they have a serious health condition, it's important to get an opinion as to whether or not you have had enough employees during enough months in the past that you're going to be covered by the FMLA, even if you don't have 50 employees now. So those of you who are kind of hovering on the brink of 50, keep that in mind. You might be covered even though you don't have 50 employees at the time somebody needs time off. Here's another polling question. We have an employee on temporary total disability supported by a doctor's note, a Medco 14. We want to run the employee's FMLA concurrently with his use of temporary total disability under workers' compensation. The employee tells us that he does not want to use FMLA. So the question is, can you make him use FMLA? So text A, if the answer is no, you can't make him. It's the employee's right to decide whether he wants to use FMLA. B, yes, but only if he returns the healthcare provider certification form. Or C, yes, and we can use existing doctor's excuses that have been filed in the workers' comp claim. And I'm going to wait until we get to at least 23 answers before going to the results of the poll. Well, we have 21 and it's been kind of staying there for a little bit. So I'll close the poll now and see how everybody did. Well, 38% of you said A, the employee has the right to decide. 29% said B, but only if he returns the healthcare provider certification form, and C, 33% of you have the right answer. The reason C is the right answer is you should run an employee's FMLA concurrently with any period of leave based upon an injury or illness that takes them off work for 3 days or longer. And that includes workers' comp leaves. If somebody is on a workers' comp leave that takes them off for more than 3 days, or where they're going to qualify for TTD, their condition almost certainly will qualify as a serious health condition under the FMLA. And Most FMLA policies specifically say that FMLA will run concurrently with the employee's workers' comp leave. If your policy doesn't say that, you should amend it to say that, because the reason you don't want the employee to decide whether or not they have their FMLA run concurrently with their workers' comp is they could end up getting more time off. What if somebody is on TTD for 6 weeks or 12 weeks? What if they're out for the same whole amount of time that FMLA would cover? And then when they come back to work, 3 months later, they want to take off for FMLA for another reason. If you have not run their time concurrently, they arguably could take another period of FMLA. There's some nuances to that because the law now lets you retroactively designate time off as FMLA, but you should do it to begin with so the employee doesn't think that they have more FMLA time coming. The other important thing to keep in mind is that even if you don't designate the time off on TTD as FMLA, the law is going to say if it's a serious health condition, they have all the rights and the employer has all the obligations that arise under the FMLA. So not calling it FMLA doesn't prevent the law from operating so that the employee has the same right to not be retaliated against, to have his job restored at the end of the leave that he would have had you run the FMLA concurrently. And I know it's sometimes a problem where the employee has a Medco 14 that the doctor is filing with the workers' comp, and you want them to fill out a healthcare provider certification form too. And don't get me wrong, I think that is the best practice, just to be consistent, that you always send out the FMLA form. But once again, if you have other information that indicates that the person has a serious health condition that's protected by the FMLA, they're still protected by the FMLA, and you can use the existing doctor's excuse. There is no requirement that you use the doctor certification form, the Department of Labor's healthcare certification form. So you can just say, okay, the Medco 14 gives me enough information to know that this person needs a leave of absence for a serious health condition. So I'm going to count that as my documentation to support the need for leave. Other common issues that arise when an employee suffers a work injury and then needs to take a leave of absence is whether you can and should keep an employee who is on an extended workers' compensation leave on your group health plan during the term of the workers' compensation leave. Can you fire an employee who's been on a long-term temporary total disability leave when their TTD keeps being extended? And finally, if you have an employee who just came back to work after 3 months on TTD, who works for 2 weeks, but now claims that she needs time off, do you have to give it to her? So these are questions we run into all the time, and we're betting that people who are attending today have these questions, and we're going to answer them for you. But first, before we go into that, we're going to cover the answer to the question you all wanted to hear. And I am going to turn it over to Morris Hawk to address the new recreational marijuana law.
Good morning, everybody. It is time to talk about recreational marijuana and its legalization in Ohio. Just the first, to answer the first question of as to what impact the new recreational marijuana law will have on drug testing for higher employers. The simple answer to that is it does. There's nothing in the new Ohio law that requires you to change your post-accident drug testing policy or your pre-employment drug testing policy. The Ohio's law specifically permits employers to conduct pre-employment, post-accident, random and reasonable suspicion testing. So there's nothing in the law that changes that. Next slide, please. I do think there's a couple questions. People had when they signed up. There's a series of questions people had with respect to this that I just want to talk about right now, and I'm just going to go through them in order. One attendee asked, "Do you think the Federal Department of Transportation will change its stance on marijuana for DOT testing for truck drivers?" And at this point, the answer to that question is no. The Federal Health and Human Services has decided that they are going to switch marijuana from a Schedule I drug to a Schedule III drug. In response to that, which just recently, the American Trucking Association submitted a letter to the Department of Transportation asking that specific question, and Transportation Secretary Buttigieg has stated that the HHS's decision to move and the DOJ's decision to move marijuana from a Schedule I to a Schedule III will not impact the Department of Transportation's current requirement that truck drivers be tested for marijuana. Another question that we received was, how does legalization affect the drug-free program that the BWC provides? And the answer to that is, again, it has not changed the BWC's requirements. So if you want to get the reduction in premiums that is offered by the BWC for having a compliant drug testing policy, you will still be required to test for marijuana. And so that provides, employers are going to have a decision to make because even in light of this, we have had clients talk to us about discontinuing pre-employment testing because of the fact that they've just had such a hard time finding employees who will, who can fill the roles and pass a marijuana test, and legalization is making that more difficult, not less. So if you, and we have had clients who've just decided, for staffing purposes, we are going to discontinue testing for marijuana at the pre-employment stage. You can do that, but if you do, you will lose any possibility for a premium discount from the BWC for complying with its drug-free program, which has not been changed. Another question I got was random drug testing and the FMLA. The legalization of marijuana doesn't change what the current law is with respect to random drug testing in the FMLA. The FMLA does not prohibit drug testing as a requirement to return to work. It also does not prohibit random drug testing. And you are, with respect to making employment decisions based upon a positive test, an employee can be entitled to FMLA leave for a substance abuse problem. But if the employer has a policy that if someone tests positive for marijuana or any other drug, that employee is terminated, then you can continue with that policy. That policy doesn't violate the FMLA as long as it's consistently applied. And that's really, if you had someone requesting FMLA for substance abuse issues, and you terminate that person for a positive test, but someone else gets a positive test and you don't terminate them, then that could create an issue for you of FMLA retaliation. But as long as you treat everyone the same, that's fine. We have another question asking about post-offer drug testing in Ohio and the new law. And again, the law doesn't impact your ability to test or to terminate or refuse to hire someone for a positive test. You can continue doing what you're doing and requiring post-offer testing. It's just the issue really is going to be from a staffing perspective, whether that still makes sense for you. Another question was, why would the BWC approve a claim for a person who tested positive for cocaine? This is not quite a marijuana question, but this is a workers' comp question. And the reason why the BWC might do that is in order for a claim to get denied for a positive test, there needs to be evidence that the injured worker was impaired at the time that the injury occurred, that the drugs in his system somehow are causally related to the accident that occurred. So for a claim perspective, you're going to need a physician to issue an opinion saying that the impairment contributed to the injury. Even if there is a drug test that's positive, that might be evidence of drugs in the system that didn't impact the injury. So in order to get a claim denied, you're going to need a physician to opine that the impairment was due to drug use. That the impairment due to drug use contributed to the injury. It also helps to have contemporaneous evidence of impairment at the time. And the last question we got, what happens if there's a positive test for a truck driver, but that truck driver was not high at work? If the truck driver is subject to the DOT requirements, nothing has changed in Ohio or anywhere else with respect to those DOT requirements. Testing positive for marijuana, that person must be removed from the driving position. That person can get treatment from a substance abuse professional and return to duty upon a positive test. Return to duty upon a negative test, or that person can be terminated. But those rules have not changed. Next slide, please. So that's where we're at with respect to the legalization of marijuana. The next topic really for us is kind of going back to the ADA, the FMLA, and the workers' compensation and how they all interact. So basic questions: what employers are covered? We've talked about employers in the FMLA, our first question, but what employers are covered by the Americans with Disabilities Act? Well, The federal ADA covers employers with 15 or more employees. Ohio's disability discrimination law applies to employers with 4 or more employees. So practically speaking, in Ohio, that's since Ohio's disability discrimination imposes the same requirements on employers that the feds do with respect to individuals with disabilities, then if you've got 4 or more employees, you need to consider the ADA when making employment decisions. With respect to, I mean, we've talked about the FMLA with respect to workers' compensation. If you've got 1 employee, you're covered by workers' comp. Next slide. So that's what employers are covered. The next issue, what employees are covered. The ADA covers all applicants and all employees. So it applies to anyone who applies for a position, even though they have not yet received the job. The FMLA only covers employees with at least 1 year of service and 1,250 hours worked within the last year. Essentially full-time employees. Doesn't cover applicants. Workers' comp, all employees are covered regardless of length of service, but it does not cover applicants. The next slide. So what triggers the law's coverage? So we've got what the employers are covered, the employees that can be covered. Well, what triggers coverage? In workers' comp, it's a compensable injury or occupational disease. In the FMLA, it's a serious health condition. In the ADA, it's a disability. So now we're going to talk about what those terms actually mean. Next slide. A compensable injury or an occupational disease, we don't have real time today to talk about all of the permutations of this, but essentially an injury that is covered by workers' comp if it occurs in the course of and arising out of employment. Another way to look at that is it's an injury that occurs during employment, during the period of time someone's engaged in employment, or and arising out of is a way of saying it's somehow related to employment. But although that can be a pretty broad definition, the example I always give is if an employee is walking on the factory floor and that employee has a seizure and falls down on the floor and he doesn't hit anything on the way down, that's not a compensable injury because it doesn't arise out of employment. There's nothing related to employment about it. But as the Supreme Court in Ohio held a long time ago, if that person has a seizure and falls and he hits a machine on the way down, then that is a workers' compensation claim because he has, there's a hazard of employment, as they put it, that has impacted the injury that he suffered. So that, in the nutshell, is workers' comp. What an injury is covered under workers' comp. For the FMLA, a serious health condition on the FMLA has a pretty detailed definition. And really the most important part of that definition is that continuing treatment, the second bullet point. But just to run through them, obviously an inpatient care, anything that requires an overnight stay in a medical facility is going to constitute a serious health condition. A continuing treatment by a healthcare provider, including a period of incapacity lasting more than 3 consecutive full calendar days, is a serious health condition. That's where the vast majority of health conditions occur under the FMLA. A period of incapacity lasting more than 3 consecutive full calendar days um, with treatment by a healthcare provider. So someone gets the flu, that or a better example, it's someone suffers a lumbar sprain. A doctor looks at him and says, "Yeah, you've suffered a lumbar sprain. I'm taking you off work for 3 consecutive full calendar days." Then that's a serious health condition. The next, any period of incapacity related to pregnancy or prenatal care, any period of incapacity or treatment for a chronic serious health condition, a period of incapacity that is permanent or long-term due to a condition for which treatment may not be effective, obviously a cancer would be a serious health condition, or any absences to receive multiple treatments for restorative surgery, or for a condition that would likely result in a period of incapacity of more than 3 days if not treated. So those are any health condition that meets any of those requirements falls under the FMLA as a serious health condition. That doesn't mean that leave might not be might be something that occurs, that FMLA leave might arise from it, but it does mean that the condition itself is a serious health condition. Next slide. So, so who decides that question? From a practical perspective, the employee's doctor is going to make the determination by certifying that the employee suffers from a serious health condition. As Nancy mentioned too, a Medco 14 might also, for workers' comp purposes, provide that information. If it says this person has a rotator cuff tear and I'm taking him off work for 3 weeks, then that Medco 14, tells you what you need to know, that you're looking at a serious health condition under the FMLA. Now, if an employer doubts the validity of a medical certification, the employer does have the ability to require an employee to obtain a second opinion at the employer's expense. There are some occasions where that might be appropriate, but from a practical perspective, it's usually the employee's doctor who makes this determination. So the next issue, so that's the FMLA. So under the ADA, disabilities are covered. So the question is, well, what's a disability? The definition is a physical or mental impairment that substantially limits one or more of the major life activities. So we kind of have to look at, break that down into its parts. So next slide. So the question is, what's a major life activity? Because first of all, so it's like, so a physical or mental impairment substantially limiting a major life activity. Major life activities are basic activities that most people in the general population can perform with little or no difficulties. If you look at the list, you can see a lot that things that could constitute a major life activity. From an employment perspective, I think it's important that to look at walking, standing, sitting, reaching, lifting, bending. Those bending is a major life activity. So if someone suffers an injury and their doctor's telling them that, well, they can't reach or they can't lift or they can't bend because of that condition, or their abilities to lift, reach, or bend are limited to a certain duration period of time during the day or certain pound limit, then that's a major life activity, and the physical impairment is limiting that life activity. Major bodily functions also constitute major life activities, which is not surprising. So next slide, please. So then the next question is, well, when does an impairment substantially limit the ability to perform a major life activity? Well, it need not completely prevent the individual from performing it. But just simply needs to cause the individual not to perform the activity to the same extent as individuals without an impairment. So, someone who's got a restriction that they have to sit every 2 hours because of a physical condition. Well, that impairment substantially limits the major life activity of standing, because an ordinary individual could stand for a significant period of time. An impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. So cancer is a disability, even because it's considered, even if in remission, what would its impact be when active? So at this point, I'm going to hand the presentation over to Barry, and Barry's going to talk about what triggers an entitlement to leave. Oh, actually, looks like I'm sorry. I believe I have this slide. um, so so I guess for now I'll proceed. What triggers an employee's entitlement to leave under the FMLA? Nothing special. An employee request for leave can be verbal or written. There's no requirement to mention FMLA during an initial request. All the employee needs to give you is enough information for you to know that the leave may be covered under the FMLA. And if once approved, if additional leave is required for the same reason, the employee is required to reference the reason for the FMLA. But initially, there are no magic words. It's someone doesn't have to ask for FMLA. They just have to communicate to you sufficient information that you can make that decision that it's necessary. Next slide.
Can everyone hear me? Can you hear me, Morris?
Yes, I can, and I will hand it over to you now.
Okay, before I went on, did you want to hold off on those 2 additional questions we had, or address them now?
Let me see. I suppose let's assume let's keep moving for now. We can address them at the end.
That's fine. Well, good morning, everybody, and just a few things before we move on with this sort of a broad picture. The medical marijuana law, as you heard Morris say, basically it does nothing. It has no effect on employment. And you might be wondering, I don't understand. What do you mean? Think of it this way. Medical marijuana law said marijuana is legal. If you're not illegally selling it, if you're just using it, you're not going to go to jail. You're not going to get arrested. You're not going to be fined. You're not going to have your plant seized. That's what it does. Doesn't say anything about employment. In fact, the only thing that addresses employment, it says this has no effect on employers. They can do what they want. ADA and FMLA. and I guess we might as well throw in workers' comp. One thing they all have in common: you can't retaliate against somebody for utilizing their rights. But other than that, they have three distinct functions. Workers' comp is if I get hurt, my meds will be paid for, and if I can't work, I'll get a paycheck. FMLA is about time off and only about time off. ADA is if I have a disability, let's talk and do something reasonable so I can do my job. That's it in a nutshell. Not shocking in any way, whether it's FMLA or ADA or frankly workers' comp. No magic words are required. Use your common sense. Listen, if it smells like ADA or FMLA or workers' comp, treat it like one. And if you're not sure, talk and ask. How do you trigger a workers' compensation claim? You can do it in writing or you can do it verbally. You can just tell your foreperson, I got hurt. You can submit a report. You can have your doc submit the first report of injury. You would hope to find out contemporaneously, ASAP. I suspect most of you have policies that expressly require it, but sometimes it doesn't happen. When doesn't it happen? Really two situations. One is the outright fraud that we're all worried about, but the other one is, are we gonna, I got a little bump on my finger. Didn't think anything of it, then it got infected. Oh, I hurt myself a tiny, tiny, tiny bit, and then it gets worse. And our job, frankly, is distinguished between someone who honestly just didn't think it was a big deal, in which case they get their workers' comp, but we also discipline them that there's a reason it says any injury, because you're not supposed to make that distinction. Tell us, at least then we know. And the true faker. Question time. Manufacturer, 75 employees. Full-time employee with 7 years of service, hurts his back lifting parts. Tells the boss, fills out the incident report, got a lumbar strain. He's off for 2 weeks. Employee calls off, sends you the doc note, and after an MRI is done, you've got a diagnosis of a substantial aggravation of pre-existing herniation at L4 and L5. Which laws do you need to consider? Workers' comp, FMLA, ADA, or potentially all? And I'll let you look at that one more time. 75 employees, full-time, 7 years, hurts the back at work, off for 2 weeks, MRI shows pre-existing condition aggravated. Well, everyone wins the pretty big consensus there. Potentially all of the above. A few people said FMLA, and FMLA was correct, but it's also ADA and workers' comp. What's the workers' comp piece? Hurt at work. What's the ADA piece? A substantial aggravation to a pre-existing condition. If you've got a pre-existing L4, L5, potentially you've got a disability due to a bad back. So it's going to be all three. There's our recap. FMLA, they need off 2 weeks. It's for a serious health condition that's more than 3 days. ADA. So when you get, remember, no magic words, when you get a request for an accommodation, what do? And most of the time, it's not going to be obvious. And what do I mean by obvious? If someone's blind, if someone's missing a limb, it's obvious. But if it's not obvious, unlike FMLA, where you're only allowed to ask the questions on the DOL's verification certification form, the ADA is open-ended. That doesn't mean ask offensive questions. It means it's supposed to be a back and forth interactive communication. So what are the things you can do? What are the things you can't do? You're allowed to talk to a doctor, whereas FMLA, you send the certification to the doctor's office, and unless you can't read the writing, or you just need to confirm it's from the doc, you're not allowed to ask anything. It's the other end of the spectrum with ADA. And for employers, when you get, as we often do, the uppity doctor that says, I'm not talking to you, they're obligated to. You don't threaten them, but you reach out to the employee and you let the employee know, your doctor's not talking to me. Your doctor, if we're going to do a reasonable accommodation, I need to talk to your doc. And if the doc doesn't follow through, or the employee doesn't make sure the doc follows through and has a discussion with you, that's the end of your duty to reasonably accommodate, unless and until the doctor comes around. You should provide a job description to the physician. Video doesn't hurt, but mainly it's the interactive discussion with the employee and the doc. That means just because someone has doctor next to their name, to not take their word for granted if they don't have the facts. Doctors tend to want to be pleasers and help their patients. And they will say, if the employee asks, can you write me a note I can't work at all? They'll typically write that note. And that's when you need to have the discussion with the doc. Well, can they do A? Can they do B? Can they do C? Can they do this job if they're having problem with weights? Can they do the job if there's a helper or extremely heavy items? Have that back and forth discussion and insist on your rights. Second, if you get a medical document, again, that's another piece of information that's going to trigger the reasonable accommodation process. Same things we've talked about. What are the elements, the key elements of the job, primary functions? Talk to the employee, talk to the treating healthcare providers, and then talk about what are the potential accommodations. As an employer, your job, your legal obligation is to provide one reasonable accommodation that will enable the employee to perform their essential job functions. If there are 6 possible accommodations that will work, talk to the employee If there's one that you can agree on, great. But ultimately, if there's a dispute, you're the employer, you get to pick one. And as long as you provide one, it doesn't matter. It's the least preferable to the employee. It doesn't matter that the employee strongly wants anyone but that accommodation. As long as it works, you can insist on it. What are some things that constitute reasonable accommodations? One is reallocating non-essential duties. Not essential duties. This isn't light duty. Non-essential duties. If it's something that you do once in a blue moon, you can probably excuse them from that. If it's a small part of the job, but there are other things that you could take your time up that would fill the space, the time and space, you can take that problematic piece, cut it away for a while, and give them extra work within their accommodation. A leave of absence, which under the ADA only has to be unpaid. Typically, our advice is if there is paid leave available, require your employees to burn it. For the very reason that Nancy talked about at the beginning. If you don't make them burn it, you've turned potentially 12 weeks of leave into 18 or 24. You can always be nice and give them extra leave, but don't handicap yourself by automatically giving them the extra leave. Reassignment or light duty, possible. Again, you don't have to relieve an employee of their essential job functions. That's not what the ADA requires. And being a lawyer, I'm going to say, except, and the except is as of 2024, if you are temporarily disabled due to pregnancy complications, that is the one instance where even if it's an essential job function, as long as they're capable of doing the job once they're over pregnancy and childbirth, then you even have to take away essential job functions. There is an exception if it would cause an undue hardship or a direct threat to either the employee or to others, then you don't have to give any reasonable accommodation. That almost never happens. I've had it happen once in my career, and that was an employee who was just in terrible health, wanted to go back to a manufacturing job that was physically stressful. The employer already had 2 or 3 heart attacks on the job. And as the employer, we were worried that we were really concerned, not just for the employer, but this guy was going to die. We didn't want our employee to die. So, well, had the interactive process, and either in immense honesty or in a slip, the doctor said, this guy's a heart attack waiting to happen. So no accommodation, didn't bring him back. But keep in mind that that is a very, very hard standard to meet. Dollars are rarely going to do it unless you're a tiny company and it's a break the company kind of expense. Direct threat to others is also going to be hard to substantiate. I gave you the one example where it was substantiated. The only other one I could think of might be where you have more than occasional seizures with an employee who drives a forklift or some kind of dangerous or operate some kind of dangerous machinery. Save that, you're going to have to find a reasonable accommodation. And in the situation we're talking about with a seizure and a forklift or some other dangerous operation, the most probable result is find an accommodation that eliminates that. Maybe you don't drive the forklift. Maybe you do something. Talk it over. That's the key. And I believe, Morris, am I passing it back on to you?
Yes. And I get to talk about the FMLA, which is even more exciting. And but the best way to manage FMLA leaves. I realize the FMLA is tricky. These are all a little tricky. I mean, the FMLA, the purpose of it, just to provide leave, unpaid leave to someone who has a serious health condition, is you would think this would be the simplest statute in the world to implement, but it's not. It's a challenge for HR because of the paperwork required and the steps required to manage the leave process. And so my hope is that listening to me today talk about this process will sort of help you and manage it and sort of break it down into its constituent parts. So there are 4 steps to managing the leave process. Notify, certify, designate, and monitor. Those are the 4 steps. And each of the steps is necessary to work through the FMLA process. Next slide, please. So the first requirement is notify. There are two notification requirements. The first one is just the general notification that posting the notice on your billboard or electronically where it can be readily seen by employees and applicants, including FMLA in your employee handbook, and providing a copy of the notice to new hires. So that's the first, just the general notice requirement. Next slide, please. And then there's the individual notice of eligibility of rights and responsibilities. And again, this is the notice providing when you provide to an employee when you acquire the knowledge that a leave may qualify under the FMLA. You should provide this within 5 business days of acquiring knowledge that the leave may qualify. The retroactive designation is possible, but it's always better to designate the time off as FMLA as soon as possible, rather than trying to retroactively designate at some later point down the line. I think it also sets starting the process now also sets acclimates your employee that this is FMLA leave and makes them more aware of their responsibilities under the Act. So the individual notice addresses whether the employee meets the eligibility requirements, describes the employee's responsibility to provide medical certification, and also outlines employee rights. So this should be given when you know that a leave may qualify. The next step is the certify. A certification should be provided at the same time that the individual notice of rights is provided. So the first documents putting the employee on notice of the rights and responsibilities. The second document, certify, is for the healthcare provider to provide information to you. And we've already talked about this earlier, but for running FMLA concurrently with workers' compensation, you can rely on the medical evidence filed with the BWC if it is sufficient to meet the requirements of certification. You should always provide the form too. But if it's a workers' comp claim, in a lot of cases, the doctors who are treating those claims are used to workers' comp forms. So they're more likely to fill out a Medco 14, listing the medical condition and the time off or the limitations than they are to fill out a certification form. A Medco 14 is sufficient. You should always provide the certification form as well. So, let's say this is not a workers' comp injury or just a medical condition. What if the employee fails to return the certification? Well, if you send a certification to someone who's been absent from work, and is claiming he has some sort of medical issue, he calls in and said, I hurt my back last weekend, I can't work. Well, if the certification is not provided, then you have the right to deny leave. If an incomplete certification is provided, you have to give the employee and the medical provider, the employee, 7 calendar days to cure the deficiency. But you can request that it be cured and that you get the information that you need to decide whether it's an FMLA leave or not. You can also contact the healthcare provider directly to authenticate and clarify. So authenticate means you provide a copy of the certification, request verification that it was completed by the healthcare provider who signed the document. The authentication is essentially, you want to make sure you have issues or concerns that the employee is just giving you a fraudulent document. So authenticate is just getting the document to the healthcare provider and saying, did you fill this out? Is this yours? Clarification is to asking further information on what the healthcare provider has put on the form. Sometimes you can't read it. Sometimes you don't know exactly what it is that they're saying. Sometimes, unfortunately, a healthcare provider could be being intentionally vague in a response to help out an employee, their patient. But you can follow up and say, what is it that you mean by this specifically? The only limitation on that is the direct supervisor can't contact the employee's healthcare provider. And you should use HR or a management employee that's not a direct supervisor to do that. And again, if the employee fails to cure the deficiency or the healthcare provider fails to authenticate or clarify, you can deny the leave. And then after, we've got notice, certify, designate. Designate is when you make the determination that the leave is FMLA leave. You provide the designation to the employee. In the circumstance where it's workers' comp and you've got a Medco 14 and you designate the leave, you should provide the FMLA form 382 designating the leave to the employee so he knows that his time off is also FMLA leave. Again, should provide that within 5 business days of having enough information to determine that the leave is for a qualifying FMLA reason. At that time, if you've got a fitness for duty certification requirement on a return to work, if that's something you require people to do when they're off in order to return, you should provide that to the employee at this time on the designation. The other important thing that a designation does is it informs the employee of what their obligations are to pay their share of healthcare premiums. And in most cases that the employees are always paying a share. I mean, I know there's some rare employers that pay the entire premium, but for the most part, employees have to pay their share, and this is the opportunity to communicate that to them so they understand. It's important to complete the designation step, because if you don't designate it as FMLA leave, and that means that you might not be able to count the time taken off as FMLA, and the employee can come back and ask for another 12 weeks of leave for another purpose during the same year, or maybe not 12 weeks or 8 weeks. If you don't designate the time off from work as FMLA leave, then you're not running through the 12 weeks of unpaid leave that the employee is entitled to. And you should run it if you can. It's only to your benefit to run it. Next slide. And then the final step to managing FMLA leave is monitoring. And this is important. This is also an important step. Let's say that, you've got the leave designated, got the person on leave. Well, you got to keep track. You can't let someone sort of fall through the cracks. You should keep track of the employee's time off. You should recertify at the appropriate time. If a certification identifies a period of absence lasting 30 days or less, you can request recertification every 30 days. If the certification, the minimum duration is more than 30 but less than 6 months, you do have to wait until that minimum duration expires before requesting a recertification. But you should, when it expires, and if the employee is still off, get it recertified. But in all cases, you can request recertification every 6 months in connection with an absence by an employee. And again, it's important to keep track. So finally, what leave is required among the 3 statutes? In the ADA, there's no hard and fast rule. If leave is determined to be a reasonable accommodation for a disability, then it needs to be a reasonable amount of leave or a reasonable extension of leave. I would say the leave is not appropriate, is not required under the ADA if you don't know when it's going to end. So it's not appropriate. It's not a reasonable accommodation for an employee's doctor to say, my employee has a heart condition. I don't know when he's going to be back. You have to, an employer is required to provide leave in certain circumstances, but only if you have an end date, if you know what the extent of leave is going to be. Open-ended requests for leave are not requests for reasonable leave under the ADA. FMLA, the leave required is pretty straightforward. 12 weeks of unpaid leave, as well as intermittent leave accounts for that. But again, you should run paid leave concurrently with unpaid leave, including temporary total disability. when someone's on temporary total disability for workers' comp, they should also be on FMLA leave. So you should always run unpaid leave concurrently with any paid leave provided to the employer or to the employee under whether it's PTO or workers' comp TTD. Finally, workers' comp. Workers' comp, no leave is provided by the Workers' Comp Act specifically. Technically, Ohio law provides temporary total disability payments, but it's not a leave statute. It's a payment statute. So, I mean, that being said, workers' comp does have a retaliation statute, unlawful retaliation statute. So, firing an employee who needs temporary total disability or taking any adverse action against an employee because of his workers' compensation claim is unlawful. But again, technically speaking, workers' comp doesn't provide a leave period. So now I'm going to hand it back to Barry to talk about workers' compensation, temporary total disability. So Barry, it's back to you.
Thank you, Morris. Two things I wanted to comment on what Morris said. One is where you get the ADA that keeps going and going like the Energizer Bunny. First, like Morris said, if you get I can't tell you, doc, how long it's going to last, then you're not obligated to give leave under the ADA. But what about where you have the doc that says 1 month and then a month goes by and they say, oh no, it's another month. And another month goes by and they just keep adding on to the end. My general practice, and I'd love to hear, Morris, what you think, and Nancy, I'd love to hear what you think. My general practice is unless there's a post-infection, I'm not talking about that. I'm talking about where it's just the same condition. I generally advise clients 3 strikes and you're out. If 3 times in a row you say person will be able to come back on this date arrives, and it's no, they can't come back with no intervening event or condition, then after the 3rd time, I generally tell my clients, cut them loose, tell them we've given you an accommodation, we've extended it, there's no reasonable indication when you're able to come back. However, if and when you are able to work with or without an accommodation, please apply. We're happy to consider you for any jobs we may have open at the time. The other comment I wanted to make about
Barry, I'm going to butt in because you invited me.
I did invite them, so please.
I actually do a somewhat of a variation of what you do. First, I make sure they've used up their FMLA if there's FMLA. And at that point is when I will have the client look to see whether, given their current doctor's excuse, if they're asking for more time beyond FMLA, given their current doctor's excuse, whether there's an end in sight. But then, like you, if they extend it again after the FMLA, I will give them at least 1 more time, and then the second time after that. So I think I give them 3 times because I count the FMLA as the first leave. But at that point, I will generally do the same thing to say, because it's no longer reasonable. You don't, the leave is not achieving the intended result of letting the person come back to work. And so once you have the FMLA out of the way, you just look at the ADA, because as Morris pointed out, there's no specific guarantee of a certain amount of leave under the workers' comp statute. So at that point, you're just looking at what does the ADA require. And now I will shut up and I won't come back unless you invite me.
And one more positive story to tell the group. Morris mentioned that the only retaliation that's illegal under the Workers' Comp Act is terminating somebody because they made a claim. That's it. And it may make it dangerous if you term someone who's just had a workers' comp injury, but that's a matter of proving motive. That's not illegal. One of our clients just got a decision from the Cuyahoga County Court of Appeals backing this up. Employee was on light duty for a back issue, worked at a child care center, was told don't lift children. In my personal opinion, it's because she wanted to hurt herself and milk it. But whatever her motive was, she disregarded her own doctor's lifting restrictions, went into a toddler room and started lifting babies throughout her back. Our client said, wait a minute, you violated, we understand it's a workers' comp claim. We'll process that, but wait a minute. We're short-staffed this week more than any other week. You were told not to lift, and you did lift. You're fired. Court said nothing wrong with that. So, back where we left off, TTD. How long is TTD? Essentially, it's either until they can come back to work or they have plateaued. So that means they've actually returned to work. Their treating doctor said you can return to work, but they haven't. That's on them. You've given them light duty within their medical restrictions. So if they don't work, it's because they'd rather eat bonbons at home. They're permanently disabled, not just temporarily, or they've reached maximum improvement. They're not going to get any better. So there's no reason to keep them on continuing on TTD. Either they can work or they can't work. Question time. An employee's on leave for workers' comp receiving TTD. How long should you keep the employee on your group health insurance? The entire time they're getting TTD, the first 12 weeks, the first 30 days, or D? It depends how long and depends how much they work and what my health insurance plan says. Let's see how our polling's going. We're still polling, but the late voters, you get to ride some coattails a little bit.
Barry, it's closed. Nobody else.
Okay. Well, the overwhelming majority is it depends, which is a very lawyerly answer and probably usually true. And we also have some people who thought the entire time or for the first 30 days. The answer is D. It could be B if you've got FMLA. And why is that? Because part of the FMLA is you are entitled to continuation of health insurance coverage by law. If that's not the case, then whether you're covered is going to be determined not by you, not by the employee, not by the employee's doctor, but by your health insurance plan. Most insurance plans, other than FMLA situations, will say if you do not work 30 hours a week, 130 hours a month, you're not covered. And even more dangerous for employers, you got to let your directly, you have to let them know. Otherwise, you're potentially committing insurance fraud. So don't undermine yourself by thinking you're doing the good thing. You're just reporting the truth, and what happens, happens. And everybody, every health insurance carrier is going to know, look, if this is FMLA, we're keeping them on. Hopefully, all our employers out there, you keep them on, but they're obligated to pay their share of the premium. If they don't pay their share of the premium, then too bad for them. That's what we talked about. Next question. Can I terminate an employee on TTD if it keeps getting extended? Boy, I think I've heard this a few minutes ago. No, so long as they are getting their TTD benefits. Yes, as soon as FMLA is up. Yes, as long as you have a policy. Or D, yes, so long as you have a policy. You review the employee's circumstances individually. When will it be plausible for them to turn to work and perform the essential job functions? Oh, geez.
Barry, once you go to the answer page, the activity is locked and people can't vote.
Oops. Sorry about that. The answer is D. And let's go back and talk about why it might be D. A, remember that case we just talked about. You are protected for making a workers' comp claim. You are not protected for any other reason. Now, you may be on the, whoever put A is actually kind of astute, because that's a different question. Can you fire somebody versus what happens if you do? And I don't mean liable for retaliation or not. I mean, whoever said yes to A was cognizant that even if the firing is legal, you might still be on the hook for TTD. You heard that right. If you fire somebody and they're on TTD, you might still have to pay them TTD. So keep that in mind. Let's go back one more time. Nobody said as soon as the FMLA is up. That is correct, because under the ADA, you have 12 weeks and 1 day doesn't mean I'm free to fire you. We have to have the interactive conversation. Do you need some additional unpaid time off? No one said yes, so long as you have a policy, because everyone in this seminar knows that just because you have a policy doesn't mean it's legal. We've talked about this already. Once it's no longer a reasonable estimate, under the ADA, you can cut them loose. And as far as TTD, as far as workers' comp, as long as it's not because they filed for workers' comp, you can fire them. And let me give you another example, because there's another case where we basically got the same result, and it all comes down to the same thing. You can not fire somebody because they said, I've been hurt at work, I'm making a claim. You can fire somebody because they did something stupid and hurt themselves. I told you about the lady lifting babies against her restrictions. What I didn't tell you about was the other case from recently. Worked in a manufacturing facility. They make dairy products. One of the machines cuts sticks of butter. And this woman was having trouble with her machine. It was jamming, it was slow. Instead of having it fixed, she just decided to take off the safety guard and stick her finger in. And she lost the tip of her finger. She got fired for it. Next question. And this time, Nancy, I'll make sure not to jump the gun. Can I terminate an employee while she's on TTD if she's engaged in misconduct? For instance, I found out she stole something before she went out on TTD. We frozen at 13. I'll give it another 10 seconds and then I'll move along. Okay. Winner, winner, chicken dinner. Yes. If you terminate somebody because they've engaged in misconduct, that's not because they filed for workers' comp. It's perfectly legal. However, to our answer A, astute in the sense, or in the law, it is formally the employee's burden of proof to show that it was for filing for workers' comp and not for the misconduct. But for most practical purposes, essentially the burden is on us, the employer, to say, no, this is why we did it, and this is proof it had nothing to do with you filing for workers' comp. Basically what we said, for all, act like the burden of proof is on you. In many ways, it essentially is. But if that is misconduct is the reason we terminated them, not because they filed for workers' comp, perfectly legal and you should do it. Now, I alluded to some bad news about and for that lovely news, I'm gonna make Morris tell you about it.
Sure. And Barry, I think your mic dropped off a little there at the end, but I know what you were saying. You were saying it's time for me to talk about the new test for temporary total disability that removed the voluntary abandonment requirement. And the doctrine of voluntary abandonment as a defense specifically that an employer could raise. You know, in the past, before 2022, if let's say the employee had employee was injured, the employee had engaged in gross misconduct, or had somehow violated employer's work rules, then if you terminated the employee for violation of a work rule, that would terminate their temporary total disability benefits. It would end their entitlement to them, because the theory was, well, that employee had engaged in misconduct that would, you know, ended his employment, and that's the reason he's not working, not because of his injury. In 2022, Ohio General Assembly passed a statute that abandoned that theory and replaced it with sort of a test that is simple, but I don't think has turned out the way employers would have liked it to. Under the statute, someone's entitled to temporary total if he's unable to work or suffers a wage loss as a direct result of the work-related injury, and the employee is not entitled to TTD if he is not working or suffered a wage loss as a direct result of reasons unrelated to the work-related injury. The problem with that language is the courts, and specifically in the AutoZone case, have interpreted that to mean termination doesn't bar an employee from an award of TTD if a doctor concludes the employee is unable to work due to his work-related injury. So in AutoZone, employee injures his shoulder. He's working light duty. He's terminated for misconduct while on light duty. He has shoulder surgery months later. His doctor says he's unable to work after his shoulder surgery because of the surgery. And the courts have held, the AutoZone case, the court held that employee is entitled to temporary total disability, even though he had been fired from his job. And this, surprisingly enough, applies currently under the law, even if, he had no new job. If he was not working at all. In this case, he had been, but I mean, so it's really, if you could go to the next slide, it really sort of, as Barry alluded to earlier, gives you something to think about when you're considering terminating an employee that's on TTD. Because TTD, if someone's let's say you terminate someone's employment, if they're on TTD, it's not going to be cut off. The TT is not going to be cut off unless a doctor's opinion states that the employee is capable of working or has reached maximum medical improvement. So the termination, it's going to be a case-by-case determination that when you consider the injured worker and the circumstances as to whether you should terminate someone, because it's going to result in a longer period of temporary total disability, because you lose, if you terminate someone for who's on TTD, number one, you lose the ability to offer light duty work and get them back, which is, if you can get them back on light duty. And number two, the employee's got no incentive. Well, some employees will be in no hurry to ever get off TTD. If someone's happy getting their average weekly, wage as awarded by the BWC, they might just stay on it as long as they possibly can, because now they don't have a job and they might not be in a hurry to get a new one or to in the gravy train. So it's something to think about when you're considering it. Temporary total under the new statute. So, and we have talked about ADA leave as a reasonable accommodation. So I think I know we've got a bit of a way still to go. It can be, as we've talked about, unless it's for unreasonable long period of time. And I do think Barry's 3-strike rule makes sense. But I am gonna, since we've got more to go through, I'm gonna send it back to Barry for the next question.
Okay. I'm going to give you a clue. Don't overthink this one. 55 employees, office employee comes back from TTD after reaching maximum medical improvement. She wants more time off for a lumbar strain, which was disallowed. Disallowed meaning it wasn't a workers' comp injury, but she does have an aggravation of a pre-existing disc herniation L4, L5. She can't lift more than 20 pounds. She can't stand more than 30 minutes. She wants 1 day off every month for an epidural so she can work the other days. We have to. And noticeably, there's no it depends. It's yes or no. All right, let's see what we've got. Wow, evenly split. I am, that's interesting. I will tell you the answer. The general answer is yes. And why? ADA. It wasn't a workplace injury, but there's no dispute. She's got a bad back. She's got a herniated disc. And she needs treatment for the bad back. Do we have to accommodate her? Unless we're going to show that giving her time off or her epidural is going to put us out of business, we probably have to give it to her. The only caveat that I would claw back a little bit is she asked for a day off. And because we have the interactive process and this, it sounds a little excessive to me, we can have that interactive discussion. Certainly you can have time off to get your epidural, but do you need a whole day? Can you go in the morning, get your epidural, rest for a little bit and come to work? So that's possible, but whether it's a whole day, half day, or half an hour to get her epidural, we're going to have to give it to her. More of the same. More of the same. We have a duty to accommodate. This almost looks like a repeat. Undue hardship. Unless it's going to essentially risk putting you out of business, just like we said before, you're going to have to give some kind of accommodation. As I discussed early on, what does the FMLA do? It does two things. One, it prevents retaliation against someone for asking for FMLA. And number two, it gives you unpaid leave. Paid if you are a smart employer and you run any PTO concurrently with the FMLA. But that's all it is. There are no accommodations under the FMLA. It's you get time off. You can get 12 weeks, you can get 2 weeks, you can get intermittent leave that adds up to 12 weeks, but you only get leave. It doesn't give you any rights to modify the job other than taking time off. And light duty, how does that play in with our 3 statutes? Workers' comp, it plays in because we'd rather not have them at home eating bonbons, even if they have to do busy work. We're going to make them come in. And by offering that, we'll pay them their regular pay, but they won't get lost wages, TTD. FMLA, it's an absolute right to leave. We cannot require them to take light duty. And if they do take light duty, they're working. So there is no FMLA, well, any part of the 12 weeks that's clocking down. And then the ADA, light duty could be a form of reasonable accommodation. It's not required, because typically light duty means they're not doing their job at all. They're doing someone else's job. And you certainly don't have to create a permanent light duty job if it doesn't exist. I think it's back to Nancy. It's been a pleasure. Thank you for your time.
Hi, everyone. Thanks, Barry. All right. And I did look, by the way, everyone, that we do not have any questions in the queue right now. We had some before, and they all appeared to be about the drug testing and the new recreational marijuana law. And I think Barry and Morris answered that question. If you're an employer, it doesn't change your right to drug test or to fire people who report with drugs in their system in violation of your policy. Since there are no questions, I'm going to finish my part of the presentation. The question is, we are a manufacturing facility with 70 employees. We offered light duty work to an employee who is eligible for FMLA, and he has been on TTD for 2 weeks. The light duty is within his medical restrictions, but he has refused to accept the work. He has not otherwise taken any time off this year for illness or injury. So, and let me see if I have control over this thing. Next slide, please. Okay, so the question is, somebody refused light duty work that they can do. Can you terminate his employment? We already have people voting. All right. Well, 85% of you, unfortunately, got it wrong. And here's why. If you're an employer with 50 or more employees, you're subject to the FMLA. And as Barry had mentioned in his last presentation, you cannot require an employee under the FMLA to work light duty, period. It appears that his health condition constitutes a serious health condition under the FMLA. And since he's only been on TTD for 2 weeks, he still has FMLA leave eligible. So assuming he's an employee who has worked the requisite number of hours to be eligible under the FMLA, you cannot fire him for refusing available work within his restrictions. And the next slide, or oh, actually, I guess I'm going back too far. The under the ADA, you do have to engage in the interactive process, but because and if you offered them light duty as part of the interactive process and they refuse it, you arguably could fire them under the ADA, but you still have the FMLA to worry about. So the major thing that would happen from an employee refusing to work light duty within their restrictions is that their TTD would be cut off. And it is kind of amazing how quickly employees return to work when they're not getting any money come in. So you'll get them back one way or the other, probably. One recap, I think this is something that was touched upon in earlier things, but under the ADA, you have a right to medical information. You are able to access all the medical information you needed to determine whether the employee has a disability and whether it requires an accommodation and what accommodations there are. And I think Barry made this point implicitly, but I'm going to say it explicitly. Unlike the FMLA, where you cannot inquire into the nature of the employee's serious health condition, although a lot of times the doctors tell you, but you cannot ask. Under the ADA, you can ask. Again, if their disability is not obvious, obviously if somebody in a wheelchair or somebody who's missing an arm, you can see they have a disability. But somebody who comes in and says, I have PTSD, or, I have, a heart condition that needs an accommodation. If it's not obvious, you are actually allowed to ask their doctor for that medical information. You can ask for the nature of the disability. You can ask the employee that. You can ask the doctor that. And, while Barry is right, a lot of doctors don't want to talk to the employers. You can have forms that you use and you tell the employee, make your doctor fill this out. And the first question could be, what is the nature of the employee's disability? How long have they had it? How long will they continue to have it? And how does it affect them? So FMLA is limited. You can't ask more than what's on the forms. But the ADA is pretty broad. And then the workers' comp, you can get any information you want, not only about that claim, but you can usually find out about prior health conditions. And we are coming up at the end of our time. So for those of you who know the Spooners, either Tom Spooner or his grandson, Joe Spooner, who's now running the company, here is the next generation. There's Harper Ann Spooner, Joe's new daughter, and her puppy. And then there's Dale Spooner, great-grandmother of Harper and Tom's wife. And I think that's a lovely note upon which to end the seminar. So thank you, everybody, for attending. And email any of us or call us if you have any questions in light of what happened in the webinar today. Thank you.
Thank you.